I'm going to discuss the law relating to applications to exclude evidence that has been gathered unfairly. The legislation is set out at Section 78 of the Police and Criminal Evidence Act 1984, otherwise known as PACE. So Section 78 of PACE states that in any proceedings, the court may refuse to allow evidence on which the prosecution proposes to rely to be given if it appears to the court that, having regard to all the circumstances, including the circumstances in which the evidence was obtained, the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. So looking at the legislation, the question is whether the evidence gathered would have such an adverse effect on the fairness of the proceedings. So what sort of material might the prosecution gather to be presented at court that the defence may wish to apply to the court to have excluded? Well, I would suggest that one of the main areas is admissions made by a defendant in interview under caution. I have previously produced videos about interview under caution and the police caution and what may be done in interview under caution, whether to make no comment, whether to answer questions, whether to give a prepared statement. I've also previously produced videos about arrest and the requirements for arrest. One of the requirements for arrest is to secure and preserve evidence, and that evidence can include material put to a suspect in interview under caution and their responses to that material. I've also previously produced a video about what can be done ahead of a first hearing, or indeed ahead of charge, and that can include requesting the custody record from the police and the interview under caution from the police. So when considering whether or not to make an application under Section 78 of PACE in relation to what is said in interview under caution, it may be possible to look at the circumstances surrounding the interview under caution, and that may be assisted by considering the custody record. So if an individual has been arrested and brought into custody and then interviewed under caution, it may be useful to look through the custody record to see whether there is any explanation as to why the suspect said what they said in interview under caution, particularly if what they have said in interview under caution is incriminating against them. So, to give some specific examples, if the individual is on medication at the time, that should be shown in the custody record. And if they haven't been provided with their medication and then have been interviewed under caution, it might be appropriate in those circumstances to make an application under Section 78 of PACE to the court to have that evidence excluded because it was gathered unfairly, because the individual was not on their medication at the time. Another example might be if an individual has no previous experience with the police, has never been investigated before, has never been interviewed before, and for whatever reason has not requested free and independent legal advice at the station. So if they have declined legal help, or indeed if they haven't been offered legal help, that might be a reason to make an application under Section 78 of PACE to have the interview under caution excluded from the evidence presented at court. Another example might be if the individual is a carer. So if they have been arrested and they are anxious to get out of the police station in order to get back to caring either for children or for elderly relatives, that might be a reason to consider whether or not pressure was put upon them in interview under caution and whether an application should be made to the court to have the evidence excluded. The application to have the evidence excluded can be made at any court: the Magistrates' Court, the Crown Court, the Court Martial. As a matter of good practice, it may be helpful to make the application to exclude the evidence at a hearing in advance of the trial. That way, if an application is made in advance ahead of the trial, then if the application is successful then preparations can be made for trial knowing that the evidence will not be presented. And conversely, if the application is unsuccessful, then preparation can be made for trial knowing that the evidence will be presented against the defendant. So it's helpful on a Section 78 application, if possible, if there's time, to present an application in advance at a separate hearing with a skeleton argument already drafted, so that if the court is to allow the application to be made, and if the application is to be successful, then preparation can then be made to prepare for the trial, knowing that that particular area of the prosecution's case cannot be used as evidence against the defendant at trial.